Yeah, please, your doctor. Also, with the consent of other side, I beg to mention item number 22, my lord. My lord, my senior is out of station due to medical treatment of Madam, my lord. So, my lord, kindly adjourn the matter and maybe fix, my lord, and November 1st week, my lord.
Please some second week November. Next, can you mention it?
May please your lordship. My lord, I beg to mention item number 30, daily list.
13.
30, 30.
Okay.
Lanet Council, Mr. A. Shad is physically not well. He is having low blood pressure, low blood sugar. Therefore, my lord, I beg to, the matter may be fixed Monday.
One day nobody will have proper blood sugar.
Sorry, my lord. Next possible day.
Monday is a holiday, sir.
Yes, my lord. Next possible day. After 1 week, maybe.
Okay. Some date will be here. Give some regular date.
May I please, your lordship?
Yes.
I beg to mention item number 31. The matter
Yes.
may be adjourned for the day as my senior Mr. R. Hussain is out of station.
My lord,
Yes,
I am
sir.
appearing for the petitioner, my lord.
Shall I call out?
Well, there is an interim order, my lord.
That will be. I think it is unlimited.
Yes, my
It
lord.
is not restricted.
Yes, my lord. But on the last day, my lord, it was, my lord, it was, my lord, directed that it will be until next day, my lord. On the last order. my lord.
Interim relief to continue. Next.
Hello.
Yes, Mr.
Lordship, I am
Kayal.
sorry, Lordship. File is handed to me recently. Check up the Lordship. Yeah, I'm taking step today itself. Other on earlier Lordship 8/9/2022 schedule taken, both by Dusty and by registered post. However, on 27 Lordship directed to take fresh step. We are taking first step today.
You will have to take fresh step.
Yes, today itself I will take.
You have replaced Mr. Gupta.
Yes, Lord.
Mr. S.P. Kayal, counsel now appears for the appeal. We shall file his appearance within a period of 1 week from today. Fresh notice to respond. Returnable after 4 weeks.
Much.
Additionally, be served by registered post lady. Next.
The order of the learned Central Administrative Tribunal is under challenge.
Now you will be appearing in this, or after we entertain it, prima facie, there will be change again.
My lord?
You appear for Union of India.
Yes, yes. No, the last occasion, my lord, directed the registry to inform the respondent. One affidavit is filed by the respondent. And here, my lord, one more thing, development has taken place that the incumbent has retired from service. So the issue was, my lord, the tribunal has ordered retrospective promotion in a post of chief engineer zone. My lord, that itself is not permissible. Now, my lord, we have already filled up that post after the stay by this honorable court.
We'll admit it for hearing. If it doesn't turn
My
up,
lord.
what can be done?
My
Lord
lord.
Mr. H. Gupta. Admit for hearing. CA will dispose it of.
My lord,
CA will dispose it of. IA.
IA, my lord, can dispose it.
Rupin bhai.
Well, in item number 3, we are
One
filing the affidavit in
One sec.
Lord.
By noted date. By 2/2021. This court has passed the following order for the order. This will be in CA, in IA. I mean IA. In fact of this case, and also considering the fact that the respondent has already attained the age of superannuation, the interim relief granted to the order dated 5/2/2021 is was to be continued till the final disposal of this appeal, the ISN disposal. Next.
So in item number 3, we are filing the affidavit in opposition to the
Service is awaited, isn't it?
We have taken steps, my lord, for respondent number one.
The other respondent, my lord, I am filing the affidavit today.
Mr. Chaudhary, you have instructions to appear for number one,
Number one, yes, lordship.
then file your affidavit, Mr. One. Govind, take it, Chaudhary. File affidavit. Available time to file affidavit, section 2. Within 2 weeks, file your affidavit. Mr. Nath.
Lordship, today we are filing.
Much well.
You must be aware about the latest judgment on this issue.
My lord, yes, I have.
Delay in passing the order.
Lordship.
So before you draft affidavit, please take care of that.
My lord, I have drafted, I'll take care of it.
So he has not raised now. After reading the papers, I felt so.
My lord, I'll go.
Mr. Chaudhary,
My lord, I am appearing in item number 5 and my learned friend is representing the state in item number 4.
There are two appeals.
for a change, you have a common cause.
No, my lord, but we are opposing each other.
We are still opposing, madam. In fact, madam, there was an this matter relates to appointment to the post of constable, madam.
But Mr. Majmudar, what about so many respondents in your appeal? Who will represent that?
Madam, they are appearing.
Mr. Chaudhary would be appealing.
Madam. And these respondents, they have filed the other writ appeal, madam.
103 in number.
Yes.
Madam, there was an advertisement in the year 2009 for the post of constable. Madam, I have prepared a short synopsis.
No, but what about para 13
Para 13. madam.
of the impugned judgment? This is for both of you. Anything on merit will not. I'm a facie, I feel, Mr. Chaudhary, that it will not fulfill the lacuna which is there ab initio, or rather conveniently, if we can use that word.
13.
Para 13 of the judgment.
Yes. There are two findings in para 13, madam.
No. First finding,
First one is, my lord, selected candidates were not implemented.
now if they are not implemented, they are directly affected. Any merit will not be able to. The best thing is to send you back, include them as parties, and let the single judge hear the matter. Because this lacuna, even we can't.
Madam, theory.
Because I was thinking on other aspects of it.
Madam.
But then after looking at 103 persons to also permit you to both of you to implead by way of an IA, that would not cure the defect in the petition itself.
Yes. Because
Maybe it is continuation of the petition. This is intra-court appeal and all those technical
No.
glitches can be taken care of. But ultimately what? Even we are making them party without they being before us. This lacuna we will not be able to cure. Prima facie, I felt so. You can think over and tell us the way out. I may defer it by a week. No, because Mr. Majmudar may not. If you want to take it,
Lordship is inclined to take a view, then after impleading them, the learned single judge should rehear the matter. Possible, kindly give us little time, we'll think it over and revert back. to
that is why I am saying next week we will keep it.
Mal.
Next Thursday. No, next Thursday bench is not available. So it will go on. But you tell us on 31st.
My lord, 31st and 1st, I'll be in Supreme Court. Can it be on any other date, my lord? 2nd, 3rd?
Any date.
My lord, 3rd,
Second, we may have many matters.
3rd, my lord.
Third. Joint request third.
please. The last pattern of instructions were sought regarding page 109 and definition of defendant.
Ms. Bhattacharya ji was to take instructions in this.
Lordship, I have received the instruction along with the application that was submitted by the deceased lordship.
Now, what is your relationship with the disease?
I am the son.
Huh?
I am the son.
Then Ms. Bhattacharya, the son would be directly dependent of the father.
Lordship.
Okay. Okay, this aspect was never considered by the state level committee that much. I have present.
No, but the question is that see, the conditions of OM dated 1/6/2015 are mandatory in nature. They are mandatory in nature.
Yes, Lordship.
We also cannot give you any leeway or exemption in it.
Yes, Lordship.
Now go to the finding of the learned single judge.
Yes, there are 12, Lordship. It's 20. Lordship, page 21. When upon hearing the learned counsel for the parties and perusal of the record, and in light of the decision referred above, the court is of the view that the conditions stipulated in the OM dated 1/6/2015 for compassionate appointment are mandatory and has to be strictly complied with. The petitioner has having the criteria incorporated in OM dated 1/6/2015 cannot be appointed on compassionate ground. There is no merit in this reputation and same shall be dismissed.
Now you read para 10 of the judgment. Please read it loud.
Yes, sir. The court has also carefully perused the criteria in the OM dated 1/6/2015, which regulates compassionate appointment to the defendant of a government servant, and is of the considered view that none of the conditions stand fulfilled for appointment of the petitioner on compassionate ground. The petitioner, however, by relying on an application dated so and so submitted by the petitioner father for voluntary retirement, has strenuously argued that the application by itself shows that the petitioner's father retired on medical ground, and therefore the petitioner can be appointed on compassionate ground by invoking the conditions of the OM dated 1/6/2015 by taking a sympathetic view.
Now read para 12.
A reading of the application dated so and so and the order dated 2/1/2015 makes it amply clear that a petitioner's father was allowed to go on voluntary retirement under FR 56, which provides any government servant may, by giving notice of not less than 3 months in writing to the appropriate authority, retire from service after he attained the age of 50 years or has completed 25 years of service, whichever is earlier. The order dated 2/1/2015 nowhere states that the father retired prematurely from service on health ground. The medical certificate relied by the petitioner cannot be said to the medical certificate issued by the state level standing medical board as prescribed in the scheme, nor it is a case of the petitioner that his father was receiving invalid pension under Rule 82 of the Assam Services Pension Rules 1969. None of the criteria of the OM dated 1/6/2015 therefore supports the case of the petitioner to be appointed on compassionate ground. The court is in agreement with the submission made by the State Council that the condition incorporated in the OM dated 1/6/2015
has to be strictly complied with. And the petitioner cannot be appointed the host of the scheme. The petitioner submission that the condition projected in the scheme must only be read as directory, and a lenient view should be taken to consider the case of the petitioner cannot be accepted. Lordship,
Because if you read your letter for retirement at page 36.
Yes.
Page 36 of
Yes,
the paper book.
yes, that is the application.
Two reasons were there, that your daughter who is studying in secondary school is alone and there is no one to take care. And second thing, 6 months you are suffering from ailment. Now, go to page 37. This is the certificate that you have incorporated.
It is the certificate by District Superintendent Tengakhat Model Hospital.
No, maybe, but it is not by now. Go to the conditions of the OM.
Lordship, sending.
Please go to the conditions of the OM. Dated
Yes,
2/1/2000.
please, 75. Lordship.
Hmm.
Yes, Lordship. Yes, Lordship. May I read the conditions? The following principles, Lordship, from notification. I mean,
So you can read from the Industries Department and the Public Enterprise Department will issue suitable directives to various public sectors for adopting such policy.
yes.
Only one dependent family member of government servant appointed on regular basis, excluding one so and so,
Yes.
who die in harness or become incapacitated
Due to accident situated
suffered
while on duty, and
Was-
is
that is not
eligible
your
for
case?
invalid pension.
and is eligible to opt for invalid pension under the so and so, that also you have not done.
Lordship, may I just
So
place?
how do you fulfill this OM?
Yes, Lordship. May I just place the facts? After my retirement, before my pension was finalized, I died within 6 months, leaving with a leftover service of 12 years.
Sir, that is a natural death. It has nothing to do with that. That is misfortune of the family. So you have not died in harness. You have died after your retirement.
Lordship,
Means your father died after he retired voluntarily, and therefore you show us that you fulfill the requirements of OM. Otherwise, why should we interfere?
Lordship, Lordship, I am not praying for interfering with the judgment, but this aspect, though I was recommended by the district level committee, this
It is
aspect was never
it is
considered.
not binding on anybody. It is only a mere recommendation. That does not create any right in you.
Yes, Lordship.
On the contrary, you were favored by district selection committee
Lordship,
for reasons known to them. We have to interpret the order dated 2/1/2015 or the memorandum as it is, OM. We can't rewrite the policy.
Lordship, there are judgments of the single judge. There is one judgment at least, which says that the conditions are directory in nature.
We don't agree.
Moreover,
agree
Lordship,
to
these are ultimately this is a policy for the benefit of the dependents. Lordship, this situation has
Your
been
father died in which year?
2014. Lordship.
So we are in 2022.
Lordship, yes, Lordship.
So 5 years you could pull up. These are not alternative recruitment process. Nothing doing. What do you want to tell us? We are not inclined.
Lordship, Lordship may give some more time if I can place something else.
At the request of Mr. B.P. Bora. 2 weeks. Next.
Please, Your Lordship. We will be allowed 3 weeks time to file our affidavit in opposition.
You want?
3 weeks time.
Next,
Mr.
service is incomplete.
Yes, ma'am.
Huh?
Complete.
Lordship, I am appearing for respondent 3. I have filed my power today, Lordship.
You have solved all of them.
My lord, notice is served properly. But they did not comply the judgment passed long back.
What are your
Lordship,
instructions?
Lordship, as per my instructions, perhaps the contempt petition filed by them is incomplete because it is filed in January 2020. A review petition was filed by Arya Mahavidyalaya in February 2020, which was disposed of in December 2021, Lordship, with the direction to the authority that in the presence of the both parties, demarcation will be conducted. These details are missing in the
You
petition.
file
Lordship,
affidavit then.
Lordship, I
Put
will
it
be
on
filing affidavit. Please allow me some
At the
time. Lordship.
request of so and so, it's done. 3 weeks. Next,
Lordship, I am appearing for the respondent corporation, Your Lordship. I was supposed to file an affidavit and bring on record the work order, Your Lordship. But Your Lordship, we have floated the tender 3 times by giving extension. And ultimately, after the final extension, 3 prospective bidders, they participated, but none of them were qualified in the technical bid. All 3 were
no, but
non-responsive.
does
So
that,
we are floating the tender again, Your Lordship.
does that prevent you from placing all those material on record?
Lordship, on last occasion, Your Lordship asked me to bring the work order on record.
Yes.
But the work order could not be given because none of the bidder were responsive, Your Lordship.
When are you
On
putting the-
15th, we are floating the tender again. On 15th of November, the last date for final submission of bid is 15th of
at the
November.
request
So
of
thereafter, if Your Lordship grants me 1 week time, after 22nd of November, I can bring the work order on record, Your Lordship.
18 to 23rd?
If I may
Yes.
submit before this honorable court,
Obliged.
on the last occasion, the affidavit filed by the corporation, if I may take your lordship to page 14,
No, we are conscious about that.
but yes, but they are allowing the person, private person to operate the park, even
No,
though
Your Lordship, that was cancelled.
there is a illegality committed by the department.
Who is operating the park?
One
Right
of the
now?
private respondent.
No one now. No one now.
No,
Since the
but-
tender process is going on, we have cancelled it. That is on record. Your
But I can show, I can prove it from the document submitted by them in the affidavit of opposition submitted on 28, 2022.
That is neither the
Well,
ultimately.
page
this is-
14.
See, Mr. Counsel, this is a public interest litigation. Don't stretch further than the element of public interest in it.
But that's what I am submitting.
You can produce the photographs. If it is run by somebody, will
But it is written in their order itself.
No.
Page
Next.
14.
next.
Obliged, Lordship.
Just who appears for the state government? Somebody will have to pay the compensation.
My lord, in the affidavit, my lord, filed by the union, they have taken a categorical stand, my lord, at paragraph number 4.
Yes.
My lord, that the National Games, my lord, 2005 was conducted under the state government under the auspices of the Indian Olympic Committee. Now, Indian Olympic Committee was not a party respondent before the learned single judge. So if your lordship permits, my lord, I may be permitted to include Indian Olympic Committee. State, my lord, the land was damaged by the authorities who had conducted. There lies the, my lord, crux of the matter.
Then
It
you
was
find,
handed over for what purpose?
My lord,
Why was it handed over? For the purposes of conducting the game.
National Games.
So therefore, you are the custodian of the land. You should have verified that to what extent the private land belongs.
No, my lord, to that
So
extent, my
therefore-
lord is absolutely correct. But my lord, in the affidavit,
This Union of India will not assume responsibility for compensation.
my lord, but
That is very clear from the affidavit.
who took possession?
possession has been, was taken by, my lord, the authorities who had conducted the National
Then
Games.
you file a suit against them.
Lordship, if I may just point out, if your lordship will see paragraph 4 of my affidavit, it is
That is
the
what we are reading.
Indian Olympic Association and the state government.
Well, my pleaded case here before my lord is that my lord, we are no longer, my lord, we are not at all negligent or nor any duty was casted on the appellants here in my lord to protect the land of the petitioner. Well, there is no liability on the part of the appellants here in my lord.
No, see, one thing is certain, Mr. That with whatever reason you agreed to hold the national game. Barabar hai? Now you took the possession. Therefore, you are liable. Pay. What else is to be done?
My lord, in the affidavit, my lord,
Arey, you forget affidavit of central government.
the land of the petitioner was neither acquired nor my lord, requisition for the purpose of holding national games. That is the pleaded case, my lord, before the honorable single judge. Now, therefore, the question here is, my lord, who has caused damage to the petitioner's land, with petitioner's land? Definitely, my lord, by the authorities. So we are not the authorities who have conducted the national game.
Mr. Counsel, you will not be able to hold any public functions like this if your state government behaves like this. Take proper instructions from some higher officer and see that this is over. Day in and day out functions are being held.
That is true, but my lord, apparently, my lord, there is no negligence. And there is, my lord, no materials on record to show, my lord, that the appellants before my lord, at this stage, they had, my lord, caused damage to the petitioner's land. The circle officer's report,
Where have you argued before the learned single judge?
My lord.
Where have you argued all this before the learned single judge?
Yes, my lord.
Show us from the judgment.
My lord. Let me kindly come to page 76, my lord.
Are the judgment of the single judge?
Yes, my lord.
So one government taken by you like this, what you are arguing in appeal. It is a 2-page order.
Yes, my lord.
Huh.
So the affidavit has not been discussed, my lord, properly.
Then go and file review. Don't find fault with courts like this. You people don't argue and then blame the court because your officers brief you in face.
Lordship may kindly come to page 77 for a moment, my lord, for my satisfaction. The last page of the memo of appeal, my lord. I'm reading it, my lord, in between, my lord. My lord, 6th line from above, my lord. The respondent number 7, that is the deputy commissioner, has filed affidavit in opposition, and it is specifically stated that after verification of the various.
भैया वो तो हमने पढ़ लिया है, पढ़ के आपसे बात कर रहे हैं. The contention which you are taking before us show is you appeared before the learned single judge.
Yes, my lord.
Then you show us that you have made that averment. File your affidavit. We'll send back the matter.
My lord, it is there in the my lord, order
affidavit. That learned single judge has said that it contradicts your circle officer's report.
My lord.
What your DC says in his office is sacrosanct, not in his affidavit of opposition.
My lord, with all respect, my lord. The affidavit says. My lord,
I think you want your DC to pay cost from his salary of October.
The affidavit in opposition, with all respect, my lord, the affidavit in opposition says that the land of the petitioner, my lord, was neither acquisition nor acquisition.
What is your name?
My lord, R. Borgozari.
You show me that you have argued before the learned single judge. Opposition don't mention affidavit of opposition. You show me that you made an averment and it is not considered by the learned single judge.
That specifically is not pleaded here.
Then if you don't plead, then you are expected, the judge is expected to give you some momentum to take contentions which you are taking before the division bench. This has become a fashion. You don't argue before the learned single judge, and when you go to the division bench, you open your wing because you are ably assisted thereafter.
We have heavily relied on, my lord, the affidavit in opposition.
That is the manner in which, Mr. Counsel, you are taking contention before the division bench. So you, luckily, you are the same counsel. Why see, Mr. Chaudhary has disowned because they also, once their name comes in banner, then their purpose is achieved. They raise their hand. Why should petitioner suffer?
That's true, my lord.
Huh? Who appears for the petitioner? Why should petitioner suffer in fight between state government and central government and your DC and state government?
Then, my lord, will give me a liberty, my lord, to file a review, my lord, in that view of the matter.
You don't need any review. You file it yourself. We'll defer to your hearing.
The difficulty here is that, my lord, in the affidavit, my lord, it is pleaded, that specifically pleaded. that
Mister, you have pleaded many things in your appeal memo. Do you think that you are arguing every ground which you have
There is
pleaded
no
in the appeal?
liability, my lord, there is no negligence on the face of the record, my lord, pertaining to the appellant. This is my precise case here, my lord.
Therefore, we'll defer it. We don't want to dismiss it today. We'll do it next week. File it, because it will now go before the regular court, because the London single judge is no more a judge.
My lord.
File if it is permissible, limitation, if it is entertained, come back.
So it's been, then kindly give me 3 weeks time, my lord.
3 weeks. देने की बात आती है तब ये सब याद आ जाता है.
My difficulty is that, my lord, I am going by the
Whether it is
records only.
central government or state government. And when you want possession of the land, your DC would have almost walked over it, because national games were there. This is the other side of the coin, and the citizens have to suffer. Why should they suffer? Next. LTR is not there.
Matter has been settled in mediation center. As per the terms of the mediation center, amount has been paid, goods have been returned.
Then in terms of the settlement, we dispose of the appeal.
Yes.
And divorce granted, my lord, that has to be made absolute by the court below.
No, we'll say that this we'll incorporate the agreement.
Yes, ma'am.
And in terms of the agreement, all the amount has been paid, today we paid till.
You just listen to you. I would, if any suggestions are there, please tell us. Meta Bill 17 of 2022. How it looks like. P.T. Das, London, Senior Counsel, assisted by so and Mr. T. Chaudhary.
T. Chakravarti, ma'am.
T. Chakravarti.
My lord.
You are for the appellant, is it?
I'm for the appellant, my lord.
For the appellant, Mr. P. Das, London, Senior Counsel, assisted by so and so for the, by an order dated 5/8/2022. This court requested the parties to remain present before the OTI Court Mediation Center on 9/8/2022. Paragraph. Feeling aggrieved and dissatisfied by the judgment and decree dated 23/12/2022 passed by learned Additional District Judge FTC Sonitpur at Tezpur in PS M number 101 of 2018, whereby the learned Additional District Judge was pleased to decree a suit filed by the respondent herein for divorce on ground of cruel is challenged before us in the present appeal. Then you write that video order dated 5/8. Mr. Chakravarti as well as Mr. Das has invited attention of this court to the report of the mediator, learned mediator dated 12 September 2022. It clearly appears from the mediator's report that the parties have settled the issue and have entered into an agreement on 12/9/2022 and have agreed as under. Take it from the mediation report. The learned counsel, Mr. Tas, submits that the total amount has been paid.
Yes,
6
my
lakh.
lord.
6 lakh.
Today they have paid 3 lakhs, my lord. On 12th of 9th, 3 lakhs was paid. Today I have received a draft of rupees 3 lakh.
Today you have received.
Yes, sir. Yes, my lord.
And the goods have been also returned.
Mr. P.D. Das states that amount of rupees 3 lakh was paid as agreed between the parties, as provided in para 6 of the agreement, and today a demand draft of rupees 3 lakhs has already been handed over to Mr. Chakravarti, learned counsel for the appellant, as agreed, mutually agreed between the parties, as provided in para 7 of the agreement. In light of the aforesaid, the appeal is disposed of. The judgment and decree of divorce is modified only to the covenant of the agreement dated 12/9/2022. Appeal stands disposed of.
In terms of paragraph, in term, I think one sentence, maybe just in terms of paragraph
Parties
two.
to act as per the agreement.
As per in terms of paragraph 2 of the report, not the apparels have been returned. All the goods we are.
No, we will say in general. As provided in the agreement, the parties have already acted upon.
Yes.
I'm obliged to.
Parties to abide by the terms and conditions of the agreement dated. The appeal stands disposed of.
Obliged, my lord.
Next. IA would not survive. IA would not survive, Mr. Shah. In view of the fact that the main appeal is disposed of, IA would not survive. Yes, sir.
Otherwise, service is completed. My friend has sent an appearance. So
It is a
let us
matrimonial.
make an attempt for mediation.
Make an attempt for mediation.
Yes, sir.
Just now you have seen it to begin by mediation. When will you remain present?
Second week of November.
Why so far? We are in the 3rd week of October, sir. Now Puja holidays are over.
Either 7 or 9.
7. To remain present before the Gujarat before the Expert Mediation Center on 7th of
I get mediation.
November.
Obliged.
The matter be placed again before this court on 22nd of November. Next.
Regarding the slow progress of the national highway from
Mr. Nair.
He is in other court. Trustee, on earlier occasion, we had submitted our.
We'll keep it at 2 o'clock. Come at 2 o'clock.
No, I think he will not come. He will still.
No, let it be in, I have also for Patel today, my lord. Let it be in any other day, my lord. Because to,
Let
No,
the
on
joint
earlier
request
occasion.
give the date. Next. No confidence. No confidence.
May please your lord. My lord, in this matter, the delay was controlled, my lord, the dusty was affected. Your lordship may kindly see the order dated 22nd of September in the IMI. It has to come up for admission now. my lord.
We'll issue notice. That is why I told my brother that this is no confidence in confidence.
We don't have that confidence in the movement.
Next.
We have not received the copy also, Lord.
That is why I told you we are issuing notice. Next.
PIL of LD. Made physiology. My lord, the matter relates to, basically we have challenged the virus of the rules, my lord. Now, what had happened on an earlier occasion, my lord, the same very rule was struck down by this honorable court. Same provision has been incorporated. Now, if your lordship would kindly take the PIL for a moment, my lord, PIL 6 of
if they see, considering the recent judgment, we are not on maintainability of PIL. Sorry, but only those students who have applied will have.
Otherwise, individual petitions are also there, my lord.
You are aware about that judgment?
Yes, yes. No, other individual petition is also there, my lord. I'm referring to the PL only for the purpose of convenience, my lord.
You can refer.
Yes. My lord will kindly come to the rule, my the earlier judgment of this honorable court, my lord, which I have annexed in the PL, my lord. At page number 60. At page 64, the earlier provision which was struck down, my lord. Rule 5.1. All applicants shall be classified into 3 categories for the purpose of allotment of seats. Children of permanent residents of the state of Mizoram as category 1. Children of other permanent resident of state of Mizoram as category 2. Children of central and other state government employees not permanently serving in Mizoram as category 3. Now, if lordships would kindly come to page number, my lord, and please come to 65 also, my lord. 65, rule 5.2. On top, my lord. Percentage of seats for category 1, category 2, and category 3. 95% of the total seats shall be reserved for category 1. 4% of the total seats shall be reserved for category 2. And 1% of the total seats shall be reserved for category 3. So this was the classification which was made, which was put to challenge, and the judgment lordships will find at page 71, operative portion. Further, my lord, I'll have to take your lordships to one more provision, my lord. Please revert back to page 64, my lord. The explanation portion, my lord. The term permanent resident means those who are geoethnic people of the state of Mizoram and have been residing permanently in the state of Assam. The term other permanent resident means those who are children of non-geoethnic people of the state of Mizoram and have been residing permanently in the state of Mizoram. So, my lord, amongst the scheduled tribe, 2 classification was made. One, those belonging to Mizoram, and other, those originally do not belong to Mizoram.
But residing in Mizoram.
My lord.
But residing in Mizoram.
But residing in the state of Mizoram. Now, please come to page 71, my lord. Paragraph 19.
Yes.
In view of the above discussion, we are of the opinion that the impune rule placing children of non-geoethnic people of the state of Mizoram in category 2 cannot be sustained. It is further observed that they have to be placed along with geoethnic people of the state of Mizoram. Correspondingly, liberty is granted to the state of Mizoram to refix the percentage of seats to be reserved for categories of candidates, as mentioned in Rule 5. Having regard to the fact that more than 2 years have elapsed, we do not consider it appropriate to interfere with the admission taken under the impune rules. Therefore, my lord, classification into geoethnic and non-geo, my lord, that was held to be bad. So this was in respect of the same rule. Now, my lord, they have amended the rule,
Now this judgment was
my lord.
it was
And against this SLP was filed, SLP dismissed, review file, review also dismissed.
Yes.
Then now, my lord, will kindly come to the impugn rule at page 45. Now we are challenging this provision, my lord. Page 45. These rules may be called Mizoram Selection of Candidates for Higher Technical Courses Amendment Rule 2021. They shall come into force with immediate effect. In Rule 5 of the Mizoram Selection of Candidate for Higher Technical Courses Rule 2016, hereinafter referred to as the principal rules, Subrule 1 shall be substituted by the following, namely, all applicants shall be classified as follows for the purpose of allotment of seats. A, open category. B, children of local permanent scheduled tribe ST Mizo resident in the state of Mizoram as category 1. Children of other local permanent scheduled tribe non-Mizo resident of the state of Mizoram as category 2. Same thing has been done.
Yes.
Children of other local permanent scheduled tribe SCS ST non-Mizo resident of the state of Mizoram as category 2. Now, my lord, similarly, category 3, category 4 has been made.
So your case is that in spite of the judgment, they have come with the same provision. That is your. case. So how can we consider all this in your IA?
My lord, no, I'm placing the PIL, the main case.
No, for PIL we can't hear
No, my lord.
like this.
No, we have no. This writ petition was filed last year, my lord. When, my lord, in spite of your lordship's order, admission was not given. There was an interim order passed. My lordship will kindly have the order sheet of WPC, my lord, 285 of 22. 285 to 22.
Actually, Lordship, today the matter was for those IAs. And last time, your Lordship, if your Lordship sees the order was that they have filed an IA for some interim relief. And we have been asked to file a reply to that, Lordship, before 30th. And we have filed a reply to that. And in the meantime, some development happened here, Lordship. What has happened is that because the Lordship refused to interfere in the matter, so like the state government has went ahead and the seats have been allotted, Lordship. So I have on 18th last, the seats have been already allotted. So like this IA, which is pending, the prayers in the IA that becomes infructuous. That's why
it can become infructuous because we had issued.
My lord, with some sense of responsibility, my friend will make submission. This is a matter pertaining to admission to an academic institution. My lord, yes. So, no, my learned friend is trying to trivialize the thing, my lord. This is not the way. I'm very sorry to say that.
I am only stating the
No,
facts.
there is no question of stating
I'm not
facts.
saying anything else out of the record.
Best thing is you deal with their opposite leader
Yes.
and we.
No, my lord, question is, it's a matter pertaining to admission to academic institution. Tomorrow, my lord, once the admissions are over, nothing will survive.
No, he says that admissions have already been given.
No,
Lots of seats have been allotted.
Allotted.
But there is an order of your lordship that will be subject to outcome of the
That
case.
we know it. Therefore, you file your. It
Yes.
will be subject to. At
Yes.
the most, we
No, my
may have
lord,
to add-
why? No, I'm just coming to the fact, my lord, why had to file the IA? These writ petitions were filed in the last time. Now, last time there was an interim order that we should be provisionally allowed to join in the counseling, which they did not, in spite of your lordship's order. The
For
orders
which the
are,
Contempt is there.
my lord,
For which the contempt is also filed.
yes.
We are conscious about that.
Yes, my lord. No, now the question is, for the current session, you have denied us counseling, opportunity of counseling on the basis of this impugn rule. So therefore, we are reiterating our challenge. On last time, the matter could not be taken up because they did not file the affidavit. Now their affidavit is on record.
Now their affidavit is filed. You file the counter and also deal with this aspect which Mr. Kalita is indicating.
Yes, madam.
And we'll hear you on IA.
Yes, I am prepared to address, my lord. Is a law point. The question is very simple. My lord, where is the
No,
part
you file your reply to this.
to the counter, which they filed yesterday?
Yes, because we have not been able to read it. Frankly speaking. Yeah, opposition also. Because it has come in the morning.
My lord, there is some urgency.
No, no, urgency, we are ready to.
My lord will kindly hear it in the first week, my lord.
In the?
First week of November, my lord.
Yes, yes, after you come back from Delhi.
Yes, third,
Third, we have many matters.
fourth, my lord.
Fourth.
Fourth will be given. Fourth. Or could it be on 27th, we'll file our reply, my lord?
The bench is not available. Bench is not available.
Will it be inconvenient on 4th, my lord? Otherwise, any delay is to our detriment.
No, no, when they have already allotted. We keep it on 4th. If necessary, it will spill over to Monday.
My lord, I'm deeply
We are indicating to you.
Yes, we'll file the reply.
You can file the reply by 27.
My lord, we'll file. Very fine.
Next.
Yeah, argument will make in this 280.
May it please your lordship. In this case, on the last occasion, lordship was pleased to issue notice, and it was in the understanding that the interim order will be considered today. We are also allowed to take justice service, which we have taken, and we have also submitted a affidavit to that effect. We have already filed it, lordship. So if lordship is pleased to take up the matter for consideration of the interim prayer today on a very minor issue.
Somebody has to appear for the other side.
They have received it. They were in discussion with their senior counsels also. My friend has informed me that maybe the clients have not contacted them. They have received it.
The clients have received it.
Client has received, lordship. To that effect, we have filed the affidavit also. We have extra copies. That is the. So on the last order, lordship was pleased to give us the direction to serve them on Dusty also. They ordered it 29th of September. Dusty service is also permitted, considering the urgency of the matter, lordship. You can take this.
And we'll see. What is the relief that
The issue is lordship page 131. That is the SOCOS notice. The SOCOS notice was under challenge. We have alleged various violations of the provisions of section 3, section 4, and section 15 of the SEBI regulation.
If we grant interim relief,
lordship,
that means we are staying the impugned
yes,
order.
lordship, and
then SOCOS notice will get revived.
the SOCOS notice, they have already came before the end. We have to take coercive, which I am submitting that we are not going to take any coercive action.
No, not. We are on the aspect of interim relief.
Lordship.
So last time you indicated it is affecting PAN India. I don't.
PAN India, yes, Lord. That is the problem.
We know these days we are in mood of PAN India, but it has to be PAN India because.
No, we have about 1,500 cases pending all across. And on the basis of this order, everybody is taking advantage. Lord.
We are conscious about the facts, but the interim relief, if we grant as we are praying for,
Lordship,
will revive the proceedings of STN. I'm sorry, the SOCOS notice.
But we will not proceed any further, Lordship. That is an assurance from this honorable.
We will record that the judgment at interim relief is granted, but SOCOS notice will not be further proceeded.
We will not act upon, Lordship.
We will grant status quo as on date.
Lordship, may be pleased to stay the interim this impugned judgment, Lordship, and we give assurance before this honorable court.
No,
We will not proceed any further.
Assurance, we will pass the order.
Yes, Lordship. That will be better, Lordship.
Because assurance sometimes No,
Lordship. If our direction is also passed, we will be more than happy.
Senior advocate assisted by so and so for the appellant. By an order dated
6 impugned order
9/2022, notice was issued making it returnable today. Those out no one appears. A copy of the affidavit of justice service is also produced on record. Having heard the learned counsels appearing for the parties by an 18th order, the effect of the impugn order is stayed, however, the appellant shall not be permitted to proceed further with the show cause notice, proceedings of show cause notice till the next date of hearing. उसमें लिखना those out no one appears for the response. Having heard till on counsel, adjourned to 28th of November.
Lord.
Next.
The impugn order may be stayed, Lord.
That we have stayed, but we have also bind you that you have not to proceed with the show cause.
Highly obliged, Lord. Deeply obliged.
Next. That will be a two of it. Mr. Nath did mention about it that he wants a two of it. Next. Mr. Kyle, we wanted some facts from you so that nothing is because if you read the judgment which you have relied upon, it is against so our High Court's judgment was also part of that judgment.
Yes.
But we'll require some factual basis of this. And the Supreme Court has allowed your appeal.
Yes, Lordship, there are 3 points were decided by the Honorable Supreme Court.
Please put it in so that nothing is left out in the judgment. In fact, my judgment is half dictated even today. But then we had a second thought that let us have all the basic factual background in the judgment.
Lordship, in the present appeal, Lordship,
you put it in a one page.
Yes,
it can be handwritten only.
Tomorrow I'll
let it be handwritten. We have to allow your
Lordship.
Read appeal.
Tomorrow I'll submit that in one page.
One page supply so that our judgment can be over tomorrow.
Yes, sir. That I'll do.
Majmudar is there.
My name is not dictated.
Even yesterday you were not there.
My lord.
Somebody else appeared on your behalf. Bezubora.
My lord,
Supreme Court has now allowed their appeal.
My lord, but when I went to the Supreme Court appeal, my lord, there is one place where it records that a certain condition was not there in their advertisement. If the condition is not there in their advertisement, in our case also, that condition was not there. So it will differ out, my lord.
It is dealt with. No. Yesterday you were not there, Mr. Bezubora. On the contrary, told us that it is covered issue. Now you can. We will not permit you.
The covered issue part was a submission by the Union of
Don't
India.
utilize your abilities of a government advocate in private matters. Also.
No, I am not trying to do that, my lord. The judgment
There you have to persist. It is covered means covered. Their appeal is allowed against the judgment of this court, which the learned single judge has relied upon. Learned single judge, Mr. Majmudar, frankly speaking, learned single judge with respect has not given any reasons. He has just relied upon the same judgment which was subject matter of the Supreme Court.
Yes.
Where the Supreme Court has allowed the appeal of the Union of India. You have a look at it. We are not in a hurry. But that typical system of Majmudar will not click here. Now I know I have completed 4 months today. Next. Mr. Majmudar, if you want to show anything, you can also give in writing. So we'll deal with it. It was virtually over yesterday, so you are lucky that you are here today. Otherwise, Mr. Barua did appear, I think. Yes, Barua.
Yes.
It is not that we are deciding it ex parte. Even the registry has placed the judgment of the Honorable Supreme Court saying that this is covered now.
So the first case was disposed of, after the other cases came up, they went up in the appeal.
That is why we are saying, if you read the text of the judgment impugned in this appeal, the learned single judge has picked up the reasoning which was there in that
Delhi High Court.
Delhi High Court and 55220 of 2012 of this court.
Yes, sir.
Both the Delhi High Court judgment, which is relied upon by the learned single judge, and our High Court judgment, both all the judgments have been overruled, and the appeal of Union of India is allowed.
Yes.
So where is the question of now distinguishing? This is not provincialism or otherwise. Next. For order structure, why unnecessarily? But with that tomorrow itself, huh? One page. Next.
I'm praying that this matter will require a substantial hearing. Today, Lordship, I'm sorry, I'm not fully prepared with the case. So I'm praying for 1 day's adjournment.
Next.
Deeply okay.
May I? Yes, Your Lordship. Lordship, on 2/6/2022, the matter is already been heard by the Honorable Division Bench number 2, comprising Honorable Justice Mr. Suman Cham and Honorable Justice Mrs. Malasri Nandi.
So what is your request? Now that bench is not available. That bench is not available. So you argue here. I can't constitute a bench. It's not a part of matter. Argue on your own.
Yes, Lordship. Yes, Lordship.
Last time. No, before us. There is no, even if there is any indication that it was heard, we will not send it back to that. I can reconstitute the bench. Out of question. If you want time today, we may grant you time if you are not ready.
Yes, Lord.
Otherwise, argue the matter.
Only after 2 weeks, Lord.
2 weeks.
The earlier occasion, there was a direction from this honorable court to seek for a mediation, but my client did not turn up, and hopefully the client of Mr. Chaudhary also did not turn up.
Try
My
once again.
client has come, my lord. I am under the instructions that the mediator is in session of the matter, and she has, my lord, apprised the registry and sought some time for extension, my lord.
Try again. There is no difficulty. It's the joint request to comply with the order dated 7/9/2022, adjourn to
I'm reply.
16th of November. Next.
16th of November.
Yes, we are granting you 2 weeks. Virtually 3 weeks. Next. Yes, Majmudar.
My lord, the circular notice to somewhat extent covered, largely covered by an earlier decision of this honorable court, my lord. Here the petitioner had
In the
challenged.
other matter, you are distinguishing. Now you say that it is covered.
No, I'm not distinguishing, my lord. It is actually covered.
No, in the earlier matter, you are trying to distinguish the Supreme Court. This is the difference in role, Mr.
My lord. My lord, here the petitioner's case is that that when we have not introduced the B.Ed degree for the post of vice principals, because the NCT requires the B.Ed degree for both teachers and principals, for teachers, therefore the rules are wrong. In this particular case, my lord, when the B.Ed degree was introduced for the post of principals, this honorable court did not find it correct. This honorable court had held that it was discriminatory. It was, if Lordship would come to paragraph 7.
Please read it.
My lord, if Lordship will have paragraph 3. First name, paragraph 3. According to the petitioners, the requirement of BTBA degree is arbitrary and irrational for the category of postgraduate teachers or vice principals. For the recruitment of the post of postgraduate teacher, neither at the time of entry into service, BTBA degree is required, nor thereafter they have opportunity to get BTBA degree. For the first time, this requirement has been provided in the amended rule for recruitment of the post of postgraduate teachers, and by notification dated 13 September 12, this requirement has been relaxed up to 1st January 15. This being the position, postgraduate teachers or vice principals appointed out of postgraduate teachers will stand disqualified for being considered for the post of principal, resulting in denial of level playing field without any valid justification. Now, if Lordship will come to paragraph 7. On due consideration, we find merit in the grievance of the petitioners.
It is clear that the amendment of qualifications required for the recruitment for the post of principal in clause 1.1 of the postgraduate teachers or vice principals appointed other postgraduate teachers, no such qualification was laid down at the time of entry into service, nor at any point thereafter they could obtain such degree. Thus, eligible candidates with 15 years service will be rendered ineligible, which is arbitrary and discriminatory. Graduate teachers being allowed to acquire these qualifications during service, which postgraduate teachers were not, and therefore postgraduate teachers could not be treated at par with graduate teachers in the matter of having BT BEd degree. Grievance of the petitioners is that we have not made the BT BEd degree mandatory for the post of for promotion to the post of vice principal. And this logic will again apply because the postgraduate teachers with 15 years of experience will not be able to participate in the promotional posts if we make the BT BEd degree mandatory for the post of vice principal.
And for principal, it is compulsory.
So for principal, we have made it compulsory. But for the post of vice principal, principal is a direct recruitment post.
Okay, one. Total seat it is. Okay, 5 photos. The pagination is in there. See, Mr. Purkash Satya and Mr. Madhuda, as my brother rightly and candidly points out that your case is that as per the NCERT guidelines, it should be BEd or BT. Now BT is gone. Now it is BEd everywhere. Ultimately, it is for the guidelines of NCERT are a recommendation or a guide. Now, state has a right to frame its own rules.
Yes, but
and it is not that without any, as the order reads 5/4/2022, for assistant teacher from 2012, BEd is made compulsory. For headmaster and principal, BEd is made compulsory. Now, it is also a matter of fact that before 2012, there are assistant teachers may be postgraduate, but he or she may not be BA.
Yes.
Therefore, in order to avoid any stagnation in there before they retire, they are made vice principal. What difference does it make? Any state will prevail. NCERT doesn't say that it is mandatory. It is not like UGC guidelines, which recently Supreme Court has said that it will prevail over the rules also.
If I may just add, Malad, the NCT also says that teachers who were appointed prior to 2010
will not be required to attain the B.Ed degree and they can continue to serve as teachers. There will be no stopping them.
No, that is on a different aspect. That is a question of survival.
Yes.
Don't mix up two issues together. Here you are promoting them to headmaster,
Yes,
to the
to vice principal.
Vice
So
principal.
that is there.
Senior most
The
person.
difference is there, but that criteria is not mandatory as far as
No,
NCERT
it
is concerned. State rule provides, Rule 13 provides. There is a provision in the state rule. It is not that they are giving promotion as vice principal without there being any rule on the state, on the rule book.
We are, my lord, challenging the rule on the ground that because, my lord, in the for the higher post as well as for the feeder post also, my lord, B.Ed is
We
compulsory.
don't find it to be malified or any.
Yes, because, my lord, this rule has come into force with effect from 2019, my lord, 10/10/2019, my lord. That has to be clarification in the rule itself that those in the provision there should be clarification note at least, my lord. Otherwise,
What clarification do you require?
it was under the earlier rule, my lord.
Principle is the same. And ultimately, what vested right you have? Who are you? What vested right you have?
I am the teacher of the particular school.
Maybe, but what you have a vested right to be promoted in any service? Promotion is a matter of right, inherent right.
Right to be considered.
And you are not affected because you are not to be promoted as headmaster or as a vice principal. You are competing for principal, where B.Ed is provided.
No, for promotion, my lord, I will be the candidate in my school, my lord, for the post of.
But if in your school, it is the rule is only an enabling provision. That a person, a teacher who is serving since so many years, 15 years, and does not possess B.Ed degree can be made vice principal. But if, for example, if you are senior most in your school, automatically you will be promoted.
Present as on today, my circumstance is that my petitioner is the senior most teacher in the school. There is no other teacher above him.
Then why are you
And
worried about it?
and my lord, he is going to return in the month of January. That's why I am pressing this to be disposed of.
No, I agree. I will have company of your client. There is absolutely nothing. Only we will have practice of writing some good judgment. Because it's not only that we don't say that it is fairly covered, but doesn't seem to be any ultra vires, any provision of the constitution.
The lordship may kindly dispose of the direction to promote matter to the petitioner to the post by because he is the only qualified senior most person as a
That is not even your prayer in the writ petition. You have challenged the rule.
Your lordship
We will say that the rule, you give up the challenge to the rule. You do one thing. You give up the challenge to the rule. We will send you to learn a single. Argue for your promotion before they learn a single.
Your lordship may dispose.
No. Why should we dispose of?
Because time is short, my lord. Time is short for him.
No. We'll send it tomorrow. By next week, Majmudar will argue there. Now rules are given up. It is a matter of on factual basis. You have selected the forum of district or division bench by writing one paragraph here or there and making prayer of challenge to the rule. You will also practicing lawyers before becoming judges. So we know why sometimes challenge to rules are there to avoid learn a single judge. That well-known formula is known to both of us. So you read your prayer.
Yes, that's good.
Page number 39 in the first matter. And so rules illegal. To modify Now you go to page 42.
Yes.
Very.
And where are E? E. You argue before the learned single judge. Hmm.
In fact, my lord, from the day the repetition was filed, there was a stay, and therefore he could not be promoted. No one could be promoted. Then the stay was vacated. We are just tabulating the seniority of the persons now.
You promote him also. He is the senior. He is the senior most. Why
If
should
he's
he-
a senior most, my lord, there is no difficulty. It will come up.
As on today, he is
Pendency
the
of the
senior.
repetition is one of the factors. I'm not saying it is the only factor. It is one of the factors.
But then
Otherwise, we are
then Mr.
finding other
Majumdar, you
seniority.
can inquire and tell us if he is to be promoted. He may give up the challenge. The matter ends there. Then he may not be required to send to learn a single judge. also.
Even without the disposal of the repetition, even if the repetition was allowed in his favor, even then he has got the B.Ed degree. He is the senior most. He anyways gets promoted.
Therefore,
They will
make
stay
a
and that-
statement. Then he will withdraw the petition.
There's also a matter of political selection, my lord, which is referred to in the rules. Is ACR has to meet up. Otherwise, my lord, there's no-
For you just take instruction and speed up the issue. The matter ends there. If he is entitled to give him promotion, then this issue will become. It has almost become academic.
Yeah.
It has become academic. Tell us by next week, Majmudar. We put an end to this controversy. Not necessarily why to. Otherwise, rules we are not. We don't find there is any illegality in that.
Item number 26. But I just simply want to note, point out one thing, Lordship. In the 1982 rules, Lordship, for promotion, recruitment by promotion, even in the 1982 rules, Lordship, there is a provision, Lordship, preference will be given.
A preference.
Preference will be given to candidates having a postgraduate degree in teaching, a degree in postgraduate teaching, BA or BT. So in the 1982 rules, Lordship, the preference clause was there. Then when the 2000.
We are on the envil of the rule which is impugned in the petition.
No.
Only enabling provision is made to see that nobody suffers. Otherwise, there is no departure or go by from the existing rules or even the earlier rules as you are pointing out.
Okay.
That is why we are saying that it has become academic in nature. What is there to show that it is ultra vires the constitution? And ultimately, it is prerogative of the employer also to provide for the qualification. A teacher working in the same organization cannot insist that no, you keep this qualification only for this post. Is it your inherent right? Tell us.
Now, Lordship, because of the National Council of Research Education, NCT Act, it has come into effect.
It is all in recommendation, sir. It is recommendatory in nature. Otherwise, the autonomy of the state is not given a go by the NCERT rule. However, if you want to argue, you can argue the matter. We don't have any, we don't suggest any shortcut. Time of SC, this was last. I think you have come for the first time. Last before holidays, he had argued the matter also. And we had stopped it. Think it over and tell us. There's no hurry. 1st of November.
Right.
At that time, you tell us how they are to be promoted.
The petitioner's status in the schools I'll have to elevate.
In all the matters. Huh?
In all the matters.
111. Yes.
May it please the Lordship. In this case, for the petitioner, the writ appellant matter is challenging the selection and appointment of the respondent number 6 on the ground that her BA degree is not recognized by the NCT.
Who document that?
Who appears for the respondent?
My senior friend appears for the respondent at 6, my lord.
I'm appearing for a private respondent number 6, my lord. And presently I'm working as regular principal of the school.
Pardon?
Presently I'm working in the school, my lord, as regular principal. The matter is actually, my lord, very simple. He has challenged my B.Ed degree. Whether, my lord, B.Ed degree is valid or not. I've taken my B.Ed degree from Assam University, Silchar. At that time, my lord, the NCT has introduced, my lord, that NCT approval is necessary. And my lord, the relevant college, my lord, it has applied for registration from the NCT. And the application was pending. During that process, I have appeared and passed. And as per Supreme Court judgment also, my lord, that if somebody has applied, the college has applied, and it is under process, my lord, the degree awarded to the students, my lord, is valid. And my lord, here, my lord, the NCT Council, Standing Council is the relevant person who can, my lord, submit that my degree is valid.
Last time also nobody appeared for NCL.
Beg your pardon?
NCT is there, my lord.
NCT is here. So only his version and his affidavit is, my lord, relevant, whether my degree is valid or not. And that much is the only.
Last time probably he was not there.
Last time he was not there, my lord. Today he is here.
My case is that, my lord, the NCT says they have extended the last date of application. They have extended the last date of application.
Mr. Barbuya.
My lord, in both the cases, my lord, one NH Barbuya is appearing, my lord. He is my additional standing counsel, my lord. So he is elapsed from another court, my lord. So your lordship may kindly timing or fixing another date, my lord.
I'll continue, my lord. He may come.
No piecemeal hearing. You have to write the judgment.
My friend is there.
No, I am not aware about this, my lord.
Who is Barbuya? He is the Barbuya?
Barbuya.
Yes, some Barbuya, my lord.
If he become free, no.
Yes, I have found.
Yes. 10 minutes.
Sit down for more than that. Ask him to be ready. Therefore, we have fixed the matter for final hearing.
Yes, my lord. That is why, my lord, on the last occasion also, my lord.
Last occasion also, I remember he was not there.
He was not there.
I have prepared the written arguments.
He is appearing in this both the cases, my lord.
But he has to be here. Next time he will not wait.
I have already read him, my lord.
I have prepared a written argument.
You retain it.
Compilation.
It is better. You give it to us when the matter starts. Keep it with you. It will be lost unnecessarily. Keep it with you. We'll take it immediately. Give a short date. After first week of November. After first week of
Any dates when we put?
After first week of November, because
Fourth week of
But
November.
I will inform him.
Please, that may be given, my lord, otherwise we are also.
no fifth, not fifth.
Date may kindly be fixed, my lord.
1 second, I'll just give you. Yes, Mr. Nath.
But from the office of the deputy commissioner, I have received some instruction. It shows that for the circle officer, Guwahati Revenue Circle, they have served some notice on the person. It was served on 20. The notice is on 29/22.
How many inhabitants are there? So many.
They in the notice have shown
perhaps these are the
67%.
So far as I know, there are 4 houses.
Only 4
in the
houses
top.
are there.
I think they have given notice to all the persons who live behind the stairs, my lord, down below. There
to be given to the house, 4 houses which are there.
Even then, possibly they are also included here.
Any objections have been received?
The notice has been given to that effect that a case is pending before the court, and if the construction is done, wall is constructed, then it will it may affect you. So if you want to say anything, you can participate in the matter. So that effect, the notice was given. In the first page note on 29-22, this is the content.
But if you turn to the third page, there are signatures of hardly 6 or 7.
In the first page, 17% are 10-12 signatures are there. Yes.
No, but what we had planned was that those 4, we had also, the bench had visited the site along with learned advocates.
Right.
So their access is not taken away because they will be able to walk down. The only problem is about the parking of their vehicle of those 4 houses which are situated. So you should have informed those 4 in particular that this road will be constructed, steps will be constructed, and the road will be closed. There will be a boundary wall of High Court.
But that has not been stated in the notice below. But I have seen in the notice that as regards only
Therefore, you give a fresh notice and come back on 31 only to those 4 persons.
Only no.
Because others have got access from the other end.
And otherwise also they cannot use vehicle because all the stairs. From top, all are stairs, my lord.
No. That is
from other side, yes.
From other side, they must be bringing their vehicle.
Yes, 2-wheeler they can.
No, even 4-wheeler.
No, they cannot bring 4-wheeler, my lord. I have gone through that road to the till the end, my lord. It's a very small road, my lord. There is no possibility of bringing 4-wheeler.
But then how do they bring their 4-wheeler?
My lord, these are small houses, my lord. No big construction in the downside, my lord. Small Assam type houses, they don't use.
Thus,
my lord,
Lordship is referring to the properties on the right-hand side, on the top, not
Yes,
on
my
the
lord.
stairs that you are.
Oh, I'm sorry, my lord. I'm sorry. I'm extremely sorry. Yes,
I have seen it myself, therefore I know the topography.
yes.
That is that the point from where this proposed construction is required.
Yes, my lord. That lordship is correct, my lord.
There are a few houses where
They have vehicles, my lord. Yes.
Because they will not be able to then park their vehicle in their houses. Once we close the door, so have the boundary.
Yes.
Those families will have to be informed specifically.
But if I would request your lordship, my lord, that if I get specifically the name of those 4-5 families, my lord,
We'll have to send somebody from DC's office.
because I don't have the idea of the area.
You were there?
Yes, Lordship. I was there when Lordship went along with the advocate. They were on the right-hand side from the point that.
In fact, Mr. Nath, we saw one car parked in the. One of
Yes,
the houses.
Lordship, on the right-hand side house, there was one car, and on the left-hand side house also there was another car and also 3-wheeler and some bikes and scooters. And in all probability, they were using the High Court Road and going on the right side.
By way of necessity, but easement will not extend to parking of cars. So that right of way is already provided by staircase.
Yes.
If we stricto sensu examine it even from the angle of easement act. So Mr. Nath, you will have to inform them.
Lordship.
The thing is you send somebody to the site tomorrow itself. And tell us, we will defer it till tomorrow.
It's a nice place. You can also take time to go and take a walk, and you'll be familiar with the terrain and the.
It is not far off.
That's only,
When
only
request the company of Mr. Das if is available for Mr. Chaudhary.
Lordship, to the effect of construction of the road, it was informed. Lordship will definitely.
It is better to inform them before
Yes.
doing anything. We don't want any further
Possibly-
litigation in this.
Possibly they are also included, but even then, rule. Lordship,
Tomorrow,
or some 2-3 days. Lordship is keeping the matter on 31st or 31st.
no, we were to keep the matter on 31st. We are
Lordship-
absolutely correct.
Lordship can do one thing.
In the
my lord.
meantime- in the meantime,
My
they will-
friend can send someone and because notice will be same, the person will go and write the name and give the notice to the person concerned.
That is
A
better.
format can be printed out and the respective names
format-
can be written and handed over the notice.
Format is already there, on 29 it is there. This is the notice.
It's Das talked to the High Court. The not for the government advocate for development commission staff group and Mr. Chakravarti for PWD department. Harry. But the order date. 29/9/2022. Walkway and or staircase is required to be provided in order to give right of way to the inhabitants of the area in question. Such is based on technical opinion obtained by the court in this PI from the expert of IIT Guwahati as well as Border Road Organizer. Mr. D. Nath, London Town Senior Advocate, Assam, instructed that inhabitants nearby the road who are likely to be affected by any further orders that may be passed have already been put to notice with a notice dated 209/2022. We however feel it necessary to inform the adjoining dwelling, inhabitants of the adjoining dwelling who are likely to be affected more. Again, we may note that the court has also visited the site in question in person. Personally. On our visit, we have found that some vehicles were parked in the four adjoining houses. And therefore, it is necessary to inform the inhabitants of those dwellings in particular that their access would be affected. Though they may not have any legal right over it. In such circumstances, the development commissioner shall issue a fresh notice to those 4/5 dwellings which are just behind the property of the High Court, Guwahati High Court, and who are likely to be affected by any further decisions that may be taken in this city. To enable DC to do so, the matter is adjourned to 31st October 2020. Copy of this order be provided to Mr. D. Nath, London Senior Government Advocate Assam Port with compliance. The report of compliance be placed on record in the next date of hearing. Then you write adjourned to 31st.
Yes.
We'll take up at 2 o'clock. Along with that,
Yes,
because
jail reform
both of
matter.
you are common, so
Yes,